How do you get the defense to recognize that your injuries are worth more than what they originally perceived them to be? Would you like to know the answer? Come join me for a walk around the lake as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. First, your attorney needs to provide the defense with copies of every single one of your medical records from every doctor you have treated with. They need to understand what treatment you received from each of those doctors, as well as what problems you have now. So you might be asking yourself, okay, well, how are they going to know what problems you have now? Well, during the course of your lawsuit, whether it's a medical malpractice case or an accident case, your attorney will be required to prepare a document called a Bill of Particulars. In New York, that is a document that alerts and tells the defense exactly what your injuries are that you are claiming as a result of the wrongdoing by the different people you are suing. That will tell them exactly what problems you have now as of the time that this Bill of Particulars is being written. Now, your case will go on for quite a while after that Bill of Particulars is written. Your medical condition may likely change. In that instance, how is the defense ever going to know about those changes? Well, most of the time they're going to learn that information from you when you give testimony in a process called a pretrial deposition. During your lawsuit, you will be asked hundreds, if not thousands, of questions by the attorneys who represent the people whom you have sued. This will be an opportunity for them to learn from you in your own words exactly what problems you have now, what limitations you have, what disabilities you have, those activities you are unable to do now that you were able to do before, as well as those limitations you have currently and what problems and pain that you have associated with doing any of those activities. The defense will ask you many, many questions about those things that you can and cannot do. So as of the time of your pretrial deposition, the defense will learn everything they possibly can about those problems that you have currently. So now you might be wondering, okay, but your case is going to go on for quite a while after your deposition. And in New York, that is absolutely true. So how would the defense know about your ongoing problems? How would they learn that your injuries really are worth much more than they perceive it to be? So how will the defense know that your injuries are substantially worth more if they only know what they were as of the time of your deposition? The reason and the best thing you can do to help improve your chances of maximizing the value of your case is to keep in contact with your attorney on a regular basis. Whether it's every couple of months, just update him or his staff about exactly what problems you have. To update him about the medical care and treatment you are receiving. To let him know what other doctors you have started to see. And then your attorney can go ahead and get copies of those updated medical records. Now we can get copies of the new doctors you are currently treating with. We now have an obligation to send off those records to the defense attorneys to let them know that you are still under the care of various doctors and that you have started seeing these new doctors because the doctors whom you were seeing could not fix or solve the problem that you had. In that instance, once we are able to send them the records, to send the defense the records, as well as send them permission slips for them to get copies of your current records, now they will have a better understanding of how extensive your injuries are, assuming they are extensive, and assuming that you have ongoing disabilities and injuries from the wrongdoing that occurred to you. So now when they reach out to your attorney and tell them they'd like to start negotiating, they have up-to-date medical records which tells them precisely what problems you have all the way up till today from the time of this incident. That gives your attorney a much better chance of maximizing the value of your injuries. And that is exactly what you want to do so that the defense, now when they discuss your case with their principals and are deciding what to do as far as a settlement strategy and a settlement position, are they going to start negotiating or not? If so, how much are they going to offer? Importantly, and we won't know this yet, what do they think your injuries are truly worth? Because think about it this way. As long as each side has the same exact records, where everybody knows all the treatment that you have received, now we're working off the same documents, the same testimony to establish what the extent of your injuries are. At that point, Now the defense is going to do everything possible to minimize the value of those injuries. Likewise, your attorney is going to do everything possible to maximize the value of those injuries. If your attorney did not provide the defense with up-to-date medical records, now you and your attorney are going to be at a significant disadvantage because now the defense has different records than what you and your attorney have. And you cannot expect the defense to have understood how extensive your injuries are if they don't have up-to-date records. That's why it is so critically important that you keep your attorney up to date about your ongoing medical care and treatment, and give your attorney the opportunity to get those records so he can analyze them and give copies of them and the permission slips for the defense to get them on their own, so now they can evaluate those records as well. And hopefully by the time that is all done, and now the defense reaches out and they'd like to start negotiating, now each side is on the same exact page. Then it will be a question of negotiation strategy to see if your attorney can extract the maximum value possible, while at the same time the defense's strategy will be just the opposite. So why do I share this quick information with you? I share it with you because hopefully this opens your eyes to help you understand the importance of keeping in touch with your attorney, not just to find out what's going on with your case, but to help your attorney maximize the value of your injuries and keep him up to date about all that's going on with you from a damages standpoint. You know, I realize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.